A domestic violence protection order application is a civil application brought by a person, referred to as the applicant or the aggrieved, asking the court to make an order requiring another person, referred to as the respondent, to do or refrain from doing certain acts towards the aggrieved. Now, the shopping list of such orders can be pretty broad and varied, but the sort of orders that are regularly made include orders forbidding someone from contacting the applicant, or from approaching them, or from telephoning them, or sending them text messages, and that sort of thing. If you've been the victim of domestic violence, there are two different ways in which you can apply to the court for an order. You can either make the application yourself by filling out the relevant form, which is available at any police station or courthouse, and filing that form with the court, or alternatively, you can just make a complaint about the domestic violence to the police, and from there the police usually, and most often will, file and prosecute the domestic violence application on your behalf. You don't have to pay anything for that, and you don't have to retain lawyers, but you should keep in mind that if the police bring the application on your behalf, it will be their decision as to how the application is run, and therefore, whilst you will undoubtedly be consulted and perhaps required to give evidence, your influence on the actual conduct of the proceedings is somewhat limited. If such a domestic violence application is brought against you and the court ultimately makes an order against you, you could be bound by that order for up to 5 years. And of course, if you breach that order at any time by, for instance, calling or texting the aggrieved when you're not supposed to, you will be liable for a criminal charge of breaching a domestic violence order, and those sorts of charges can attract some pretty serious penalties, including imprisonment. It is important to understand that while many applications involve allegations of criminal behaviour, such as assaults or threats, these domestic violence applications are in a civil jurisdiction, meaning that the court needs only to be convinced the allegations are true on the balance of probabilities, not beyond reasonable doubt. So there's a lower standard of proof in domestic violence proceedings than there are in criminal matters. That, of course, benefits the person asking the court to make an order and puts a greater onus on the person accused of domestic violence to refute any allegations being made, regardless of their merit.